Nota, eu passo a palavra à Scarlett Dias com esta indicação de que nos vai falar sobre direitos humanos, moral principles, social justice and development, portanto, direitos humanos, princípios morais, justiça social e desenvolvimento. You have the floor, thank you.
Good afternoon, everyone. My name is Scarlett Dias from Goa, India, and my paper is entitled Natural Law and the Emergence of Human Rights. True law is right reason in agreement with nature. It is of universal application, it is unchanging and everlasting. What are human rights? In simple words, human rights are nothing but entitlements, which are due to every man, woman, and child by simple nature that he or she is a human being. Now, these rights are available to all people, irrespective of religion, gender, sex, or nationality. Whatever adds to human dignity and fundamental freedom is nothing but human rights. Now, as fundamental rights, they cannot and rather should not be taken away by any act of the state. Human rights are described also as common rights, for they are available to all people, and much like the common law in England was also available to all, and different from any local body of customs. Now, in short, human rights are nothing but claims which an individual has against the state. The establishment of these rights and raising them to their current legal standards can be thought of as a process of natural law, which then was translated into natural rights and then formed modern-day human rights as we know them. The credit of giving birth to human rights goes to the Greeks. It was later reinforced by the Romans, who developed jus civil and then it was further accompanied with jus gentium. Jus gentium was reinforced by natural law, as it was commonly called. It was a sum of those principles which ought to control human nature, as they were founded in the very nature of man as a rational human being. Now, it was what is reasonable against what is arbitrary, what is natural against what is convenient, what is for social good against what is for personal will. Natural law thus personifies those principles of justice which were the command of right and reason. They were perpetual and absolute. The roots for the protection of human rights can be traced as far back as Babylonian laws. Now, Babylonian king Hammurabi issued a set of principles of laws to his principle called Hammurabi's Codes. They established things such as fair wages, offered protection from poverty, and required charges to be proven in trial. Assyrian laws, Hittite laws, and the Dharma of the Vedic period in India also devised different sets of standards by which the obligation of one was provided to another in the manner prescribed. Now, furthermore, all the world's major religious movements have a humanistic principle that supports human rights despite of their difference in contents. According to Grotius, a natural characteristic of human beings is a social impulse to live in harmony with others. Whatever conformed to the nature of man and women as rational social beings was right and just, and that which went against this very nature of man was considered to be unjust. Now, Grotius defined natural law as a dictate of right reason. Throughout the 17th century, the Grotian view of natural law was refined and transmuted into the natural rights theory. The natural rights theory can be said to be closely related to the modern-day theory of human rights. Now, John Locke was the chief exponent of this theory. In his book, The Second Treatise on Government, in 1690, he stated that men and women lived in a state of nature whereby they were free and equal. Now, accordingly, to avoid any hazards or chaos of this state of nature, they entered into a body politic that it was the duty of this body politic to ensure and preserve these inalienable rights of man. And any government which failed in the said duty had to forfeit the validity of his office. Now, divine natural law. Divine natural law represents a system of principles believed to have been revealed or inspired by God or some other supreme or supernatural human being. These divine principles are typically reflected by authoritative works, such as religious writings, such as scripture. For example, in the case of Edwards versus Aguilar, the Supreme Court said that the founding fathers believed that there was a God and the inalienable rights of man were rooted in him. Secular natural law then came to replace the divine natural laws of God with physical, biological, and behavioral laws of nature as understood by human reason. Secular law elevates the capacity of the human intellect over the spiritual authority of Scripture. According to another school known as the historical natural law, according to this school, the law must be made to conform with well-established but unwritten customs, traditions, and experiences that have evolved in the course over history. In order to combat the inadequacies and injustice of man-made law, one was to appeal to a higher law, which was known as natural law. Now, eventually, this concept of natural law evolved into natural rights. This change reflected a shift in the emphasis from society to that of the individual. Whereas natural law spoke about curbing the excessive state power over society, natural rights gave individuals the ability to press claims against the government. The modern conception of human rights can be traced as far back as to the Enlightenment political philosophy, primarily in England, France, and the United States, to establish limited forms of representative government that would respect the freedom of individual citizens. In England, the earliest charters were found in 3 British constitutional documents after the Glorious Revolution of 1688. Now, this revolution was a direct result of the arbitrary rule of King James II, who reigned in 17th century England until he was forced to abdicate the throne. The first document would be the Magna Carta of 1215. The English barons protested the heavy taxes and were unwilling to let King John rule again without some concessions in their rights. The overreaching theme of the Magna Carta was protection against the arbitrary acts of the king. Land and property could no longer be seized. Judges had to know and respect the laws. Taxes could not be imposed without the consent of the people. There could be no imprisonment without trial. Merchants were granted the right to travel freely within England and outside. The concept of trial by jury was introduced, which provided for protection against arbitrary arrest and imprisonment. The Magna Carta established that the power of the king was not absolute. Later came the Petition of Rights in 1628, which was written by the Parliament as an objection to the overreach of authority by King Charles I. Drafted by the House of Commons for the redress of grievances, the subjects were expected a remedy and compensation for the wrongs they suffered at the hands of the Crown. In 1689, the Bill of Rights gave further impetus to the cause, laying down limits on the powers of the monarch and setting out the rights of the Parliament. It was in the late 17th and 18th century that a need for written guarantees of freedom was felt. This manifested into the United States Declaration of Independence. The British government's stand was that the colony should also share in the taxes which were used in their administration. However, the people of the colonies held that as they had no representation in the British Parliament, why should they be forced to do so? And they declared no taxation without representation. Ultimately, this led to the independence of the people of the United States and the downfall of the tyrannical government, and resulted in the Declaration of Independence of 4th of July of 1776. This was a unique document drafted by Thomas Jefferson, which attacked not only the divine right of king, but also a government which had no reflection on the will of the people. The Virginia Declaration of Rights included certain specific liberties which were protected from state interference. Of more lasting importance is a series of amendments to the US Constitution adopted in 1791 as the American Bill of Rights. In later developments, a Declaration of Rights and Duties was prepared by the Institute of International Law in New York in 1929. In France, the doctrine of les Lumières, or the Enlightened, was that of individual liberty against the absolute monarchy, the religious tolerance against the fixed dogmas of the Roman Catholic Church, and the consent of the governed over the divine right of the king. Now, the French Declaration of Rights of Men and Citizen recognized many rights, such as all men are born equal, the state shall preserve the natural rights of man, all men shall be presumed innocent unless judged guilty, there shall be no taxation without consent of all citizens. Influenced also by the doctrine of natural right, the rights of man were held to be universal, valid at all times in every place, pertaining to human nature itself. It became the basis of a nation of free individuals protected equally by law. The Declaration was the core statement of the values of the French Revolution and had a major impact in the development of democracy in Europe and the world over. The Bolshevik Revolution in Russia in 1917 marks yet another chapter in the field of human rights. Now, prior to this revolution, human rights consisted of only negative rights. However, this revolution incorporated positive rights as well. Positive rights would mean rights which require some enforcement mechanism by the state, and hence it included socio-economic rights. Thus, the concept of human rights is comprehensive in its nature and content. It was during the years following the adoption of the Great Declarations that there was a decline in the popularity of natural rights. The reasons were political and philosophical. Politically, the great monarchies of the 19th century treated human rights as dangerous revolutionary doctrine, which would be effectively utilized by emerging democratic and socialist movements. Notwithstanding the decline of natural law and natural rights, the atrocities of the World War II heralded the rebirth of these rights as modern human day rights. The atrocious carnage of the Nazis against the Jews and against other races in the Second World War resulted in a resilient crusade for international protection of human rights. A legal duty to protect human rights includes a legal duty to respect them. This led to the development of various human rights organizations. After the failure of the League of Nations, calls came from around the world for the establishment of another organization for recognizing these rights. This came to be known as the United Nations. Now, the United Nations Charter, which was then further developed in the year 1945, is a physical manifestation as far as respect for human rights is concerned. The Universal Declaration of Human Rights is where the rights were formally proclaimed, and it came to be known as the International Magna Carta, and it has hence adopted more than 100 human rights documents. It is stated as a justification for the actions taken by the UN. It is taken as a yardstick for the measure of the human rights at the international level. As this was a mere declaration, it had no legally binding effects. Need for an enforcement mechanism was required, and therefore the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights was thus developed. Non-governmental organizations also play a key role in protecting human rights. Some important non-government organizations would be Amnesty International, Human Rights Watch, and Survivors International, which monitor the actions of government and pressure them to act according to human rights principles. Therefore, human rights, as we call them today, can be thought of as an extensive process of thoughts which manifested into ideas. Human rights are rights which are available to all by very nature that he or she is a human being. They are absolute, inalienable, and indivisible. To deny a person of their human rights would be to challenge their very humanity. Thank you.